హలో
హలో హాయ్ అండి.
హలో నమస్తే. ఓం వెంకటేశయ్య. స్టార్ట్.
నమో వెంకటేశయ్య. బాగున్నారు సార్?
అవునా బాస్?
మ్యామ్ స్టార్ట్ చేయండి, ఎందుకు ఇంకా ఆలస్యం? నిర్మలా మ్యామ్ ఉన్నారా?
Okay. Yeah. Okay.
అంటే
First
if you
question.
have read, ma'am, if you have read through the entire thing, don't have to. You can just summarize also.
Okay. Sorry, అయితే ఫస్ట్ క్వశ్చన్ ఏంటంటే basically the term vegetables in sales tax act లో vegetables అనే term చెప్పారు. Does that include betel leaf, ginger and sugarcane to qualify for exemption from sales tax? Vegetables in sales tax have been qualified for exemption, so it not defined in the act includes betel leaves, green ginger and sugarcane to qualify for exemption from sales tax అని అడుగుతున్నారు. Will they qualify అని? So the issue is, the legal issue that must be decided is whether betel leaf, sugarcane and ginger are vegetables for the purpose of sales tax and they therefore qualify for exemption from sales tax. అవి అసలు వెజిటబుల్సే కాకపోతే క్వాలిఫై నాన్ క్వాలిఫై క్వశ్చనే రాదు. బట్ షుడ్ దే బి కన్సిడర్డ్ యాజ్ వెజిటబుల్స్ అనేది ఇష్యూ. ద ఇష్యూ మస్ట్ బి డిటర్మిన్డ్ with reference to the principles of statutory interpretation that applies to tax legislation. So tax, we know that tax legislations and penal legislations are come under strict construction. So strict construction of exemption clauses. So are you able to hear? Are you guys able to hear me?
Yeah. Yes, ma'am.
Okay. So strict construction, but exemption clauses వచ్చేసరికి యాక్చువల్లీ కొన్ని చోట్ల లిబరల్ కన్స్ట్రక్షన్ యూజ్ చేస్తారు ఎగ్జామ్షన్ కి మాత్రం. The rule is strict construction, but when it comes to exemption, the court apply liberal construction. అది గుర్తుపెట్టుకోండి. I'll go read ahead. The common principle of interpretation of tax legislation is that exemption provisions in tax statutes are to be construed strictly and narrowly. Ikkada exemption kuda strictly and narrowly. The reasoning behind this principle is that exemptions present departure from the norm of general tax liability, and as a result, the onus is clearly on the taxpayer to establish that it falls clearly within the bounds of exemption. Any ambiguity or doubt will be typically settled in favor of revenue under exemption law. Common parlance rule, popular rule ఏంటంటే, where the statute uses the term without defining it, courts tend to apply the common parlance or popular sense rule. This rule holds that the word should be interpreted according to its ordinary, popular and common use by the general public and the public dealing with the commodity, rather than reliance on highly technical, scientific, botanical or specific definitions. The rule is intended to give effect to the legislative intent of the common man. సో ఇక్కడ కేసు ఏంటంటే రామ్ అవతార్ బుధియా ప్రసాద్ వర్సెస్ అసిస్టెంట్ సేల్స్ tax officer. It is exactly the same case. What is the Supreme Court telling? The appellant was a dealer in betel leaves and claimed an exemption from sales tax under the provision exempting vegetables. So the Supreme Court ruled decisively that betel leaves do not fall within the meaning of vegetables in common parlance, even if they were from a plant. So adi dantlo undadu. The court took a restrictionist approach, saying that exemption clauses in taxing statutes must be constructed strictly, and unless the SSE is clearly covered by the exemption, he is not entitled to it. So నేను ఇందాక చెప్పింది మర్చిపోండి. Exemption clauses also under tax laws are strictly constructed, meaning they are strictly looked into. Language, everything is verbatim looked into for exemptions also under tax laws. Legal principle. It was made absolutely clear that in this case, vegetables, when not defined in tax exemption statute, must be construed strictly ante avi ento antavarake aloచింchali, and it in popular sense or common culinary understanding. So this is the deal. So it's strictly vegetables ante vegetables, nothing else. Statutory application ఏంటంటే is not defined in the statute in any sense or way. Vegetables అనేది define చేయలేదు. The General Clauses Act generally applies to the same logic to undefined terms of. So statutory application pakkan vettandi, it is very confusing. The second case law is Commissioner of Sales Tax Madhya Pradesh versus Jaswant Singh Charan Singh. The issue in question is whether the term coal was part of specific taxable category of goods. if everyone agrees, I'm going to skip reading this because the first case study, Ram Avatar Budhiya Prasad versus Assistant Sales Tax Officer, is much more relevant and direct. Is it okay, or you want me to go through the second case also?
No, it's okay, ma'am. Go ahead. Yeah.
So what is the statutory reference? The principle clearly stated here are important when applying interpretation methods to taxing statutes, with the additional requirement that the intent of Parliament, specifically with regard to definition of whether goods are taxable or exempt goods, be clear from ordinary meaning of the terms used. So ordinary meaning lo oka vidhanga undachu, but what the legislature intends to, it might be different. So ikkada em vadarante, this brings us to the application of all rules and examples above. Betel leaves is chewing not vegetable. Ginger, green ginger is also, it is the ingredient but not eaten like a regular vegetable. Standalone vegetable ga cheskoru. Sugarcane, of course, is not a vegetable, not consumer vegetables. So ఈ application ఏం చేశారంటే ఈ మూడు కూడా they don't qualify as a vegetable because they cannot be cooked standalone. In all the cases cited above, the products betel leaves, green ginger, and sugarcane are clearly not defined as vegetables in common parlance to a consumer or trader. When applying the strict construction rule in regard to exemption clauses in tax statute, these items do not fall under the exemptions of vegetables in common parlance. So they don't fall under. So conclusion is, as the term vegetables is not defined in the Sales Tax Act, we must interpret the meaning of vegetables by adopting the principles of statutory interpretation, namely both the common parlance rule and strict construction approach to exemption clauses in fiscal legislation. So tax clauses, taxation statutes are always strict construction. Whatever is written is understood. That's all. You cannot infer over and above, beyond, and it is whatever is written. In accordance with the legal analysis, we conclude that betel leaves, ginger, and sugarcane does not fall under the term vegetables for the purpose of claiming an exemption as sales tax, and as a result, we affirm they remain taxable. So they will remain taxable because it is not explicitly mentioned in the tax statutes. And strict construction law, they will not add anything other than what is there written exclusively, literally in the statute. So in this case, this is the decision that strict construction is applied for the tax statute and only vegetables qualify, nothing else. Second question is, I hope everyone is okay. I'm moving forward. Second question is,
మ్యామ్ సారీ, ఒక చిన్న ఇష్యూ ఉంది ఇందులో. ఏంటంటే there is a Supreme Court ruling that green ginger is a vegetable అని ఇచ్చారు. So either we can say all of them don't fall, or we can say betel nuts, sugarcane don't fall into vegetable category and green ginger falls.
ఎక్కడ ఇచ్చారు అది? మీరు అంటే ఆన్లైన్ చూస్తున్నారా?
జస్ట్ గూగుల్ చేస్తే చెప్తుంది అది.
Okay.
This Google is green ginger a vegetable ante no, as per Supreme Court ruling it is not vegetable.
Yeah, it is not
green
a vegetable.
Ginger, what happened in one of the other rulings, they claim that green ginger is grown locally and home gardens law, they grow it and use it for cooking purpose and చెప్పి ఇచ్చేసినారు. So Supreme Court also వేణుగారు అన్నట్టు it said that green ginger could be considered as a vegetable అని వచ్చింది. Because it's grown in a home garden.
Okay, interesting. So how do we conclude this then? Hello?
Yeah. I'm conclude ante basically the point is you can say, I'm share okay. Ma'am, what we can say is, if you want to go technically, betel leaves, sugarcane are not exempted, whereas green ginger is exempted as per the Supreme Court ruling. And rasi green ginger మీద అయితే పడుతుంది వాళ్ళకి, ట్యాక్స్ అయితే కట్టాలి అని రాయాలి.
Okay. Sorry.
అది మేడం.
Okay, then shall I go to the next one?
Yeah, ma'am.
One provision of a penal statute is subject to interpretation in two ways. Okay, penal statute law, okay, provision can have two interpretations. Either interpretation, one interpretation leads to either the conviction of the accused or acquittal. So which interpretation should a court prefer? One, okay, interpretation it is convicting the person. The other one is acquitting the person. So which one should the court prefer ani adugtunnaru. So the issue is, the basic legal issue is, in a given situation where a penal provision in a statute is subject to two equally plausible interpretations, both are possible, one leading to conviction and the other to acquittal, which interpretation should a court prefer, if at all, and what legal basis explains this preference? This legal problem relates to the reasons and underpinnings of construing criminal laws. So criminal laws or penal statutes, again, it's a strict interpretation, but when it comes to the accused, it is liberal interpretation. Anyway, strict interpretation of penal statutes with the rule of lenity only. So what is the rule of lenity? The governing principle of criminal law is that penal provisions must be strictly construed. This doctrine, commonly understood as the rule of lenity or strict construction, requires any ambiguity, doubt, or vagueness in a penal statute to be interpreted in favor of the accused, the person on whom the penalty is sought to be imposed, not on the prosecution or state. So along with strict construction, if there is vagueness, then it will be the rule of lenity will apply. The underlying philosophy is that no one should be penalized without the law unequivocally, explicitly, and unambiguously making it punishable. The burden is on the legislature to clearly convey its intentions to create the offense. So our law lo clear ga cheppali offense create cheyali, ledu ante it will be in favor of the accused only if it is ambiguous. Principle against retrospective criminal law and vagueness. Ikkada retrospective rule chadavalsina avasaram ledu actually, because he is not saying it is retrospective. He committed a crime and there are two interpretations. He did not commit a crime, he is alleged, he is a convict, and there are two interpretations. So I am not reading the principle against retrospective criminal law and vagueness because it's only confusing. Is that okay, or do you want me to read?
No, it's okay, ma'am. Don't read.
Yeah.
Go ahead.
Yes. Even the general clauses lo kuda this doesn't come, because it is nothing to do with repeal or retrospective application. So I'm skipping even the General Clauses Act. Only thing that applies here is strict construction of penal statute with the in concurrence with the rule of lenity. This is good pettukovali. The cases are quite interesting. Tolaram Relumal versus State of Bombay. The case concerned the interpretation of provision under Bombay Money Lenders Act, which provided for penal consequences and was capable of two constructions. So it was capable of two constructions. The Supreme Court held that the provision in penal statute is capable of two reasonably possible meanings. The court must adopt the interpretation which is favorable to the accused. The court stated that the accused can only be punished where the commission of an offense is clearly established from the clear and unambiguous language of the statute. When the commission of offense is clearly, only when it is any questions in relation to the meaning of words used have to be taken in favor of the person. So if there is a clear representation in the statute very clearly, then it can be strictly construed. Any vagueness should be understood in favor of the accused, should be interpreted in favor of the accused. Legal principle. This case represents a historical precedent with respect to the rule of lenity in Indian criminal jurisprudence, and reaffirms that ambiguity in penal law should be to the benefit of should be interpreted to the benefit of the accused. Adi. This is Tolaram Relumal versus State of Bombay. Chala chotla ee case repeat ayindi. So guys, please read. R.S. Naik versus A.R. Antule also repeated in quite a few instances. So the facts is the case involved the interpretation of Section 5(1) D of the Prevention of Corruption Act 1947. This is related to criminal misconduct by public servants. So while the case did not deal with two choices of actions and take two interpretations levu, which suggested a conviction versus acquittal, the Supreme Court in Antule reiterated in no uncertain terms the principle against an expansive interpretation of penal laws. The court stated inter alia, courts cannot stretch the words or use the implied meaning in an effort to create or expand a penal offense which Parliament has not clearly and expressly stated. The accused must be given the benefit of any shadow of doubt created by the vagueness of statutory language. So what happened is that the court said that whatever is written. I cannot expand it further to mean more and increase the scope, because it's a penal statute. It will be read as how it is written. So the judgment emphasized and set out legislative function is to define offences in a clear and precise way, and the judicial function is to interpret them in a way that will not be exceeded. So there will not be any judicial activism in place. The judiciary will read what is given. Legal principle. This case contributed to the strict construction rule and discouraged the exercise of creativity by the courts in extending the reach of criminal liability, and recognized that the accused deserved the benefit of doubt where there exists ambiguity in statutory language. So this we have to remember. Penal statutes and taxation statutes, ఈ రెండు కూడా strict construction, but when there is vagueness, it's always interpreted in terms of being beneficial to the SSC or a taxpayer or the person who is accused of a crime. So the rule of lenity works towards their favor. So that's the thing. Now, application. Applying the clear law and facts to case. Preference for acquittal. So there is a preference for acquittal. Because of Tolaram, the judicial officer must prefer interpretation of penal provision which results in acquittal of the accused. Then respecting legislative intention. As held in Antule case, no judge has the right in the name of statutory construction to extend criminal liability by a creative or extensive construction. So they cannot expand the scope of the law. If the legislature does not signal enough clarity of intention in criminalizing a particular act, the court cannot assume to do so by opting for one or two available constructions that would result in conviction. This would be extension of legislative extension in the domain of criminal law for which the Constitution does not make provision in the principle of separation of powers. Idantha nothing, but anyway. So what it is saying is it cannot expand how it wants. It should be read verbatim. And the rule of lenity applies. This preference in cases of ambiguity, when there is ambiguity, amounts to implementation of the rule of lenity. What does the rule of lenity say? It resolves ambiguity in favor of liberty and not degradation of state power. So in favor of liberty and protection of human rights, the rule of lenity applies. So what is the conclusion? In either situation where a penal provision from legislation can itself be read in two separate constructions, which results in the conviction of the accused under the distinct action via statute and the acquittal of the accused. So when two interpretations, one convicting and one acquittal of the accused, the judicial officer must prefer the construction that results in an acquittal of the accused. So it should be in favor of the accused only when there is ambiguity. So I'm not reading the rest of the explanation because it's just a repetition of what we read. Is that okay? Or any questions, debate on this?
No, okay, ma'am. I think it should be good. Yeah.
Okay, going forward to the third question. What is this? The primary legal question is two-pronged. There are 2 points in this question. In what manner should a court resolve the conflict of apparent inconsistency between two or more provisions of the same act while taking into account the integrity and purpose of the legislation? So apparently there is a legislation and that legislation has several provisions and two provisions have come into conflict with each other. So how should that be dealt? Ensuring that, they are saying that the integrity and purpose of the legislation should be kept intact. It cannot be compromised, but the conflict between the two provisions should be resolved. That is point number 1. Point number 2, in the event of a conflict between substantive law provisions and procedural law provisions from the same or different statutes, which is preferred over another and what rationale exists? So this is the second part of the question. There are substantive law provisions and procedural laws. We know substantive laws and procedural laws. And there is a conflict between the substantive and procedural laws, whether within the same statute or it can be two different statutes. So what should be the preferred method? Which one would reign supremacy over the other? So this is what is the question. Now, issue: how should a court resolve conflict or inconsistency between provisions of the same statute? That is question number 1. Question number 2, in a conflict between substantive and procedural provisions, which prevails and why? That is question number 2. So we'll deal with question number 1, which we all know is the application of rule of harmonious construction. What does that rule say? when there are two provisions that are in conflict with each other within a statute, the rule of harmonious construction should be applied. The central principle is this is the first and primary rule used if there seems to be a conflict between two or more provisions from a single statute. The courts must try to interpret the conflicting provisions in such a way that they both can coexist and be enforced without either being rendered useless, purposeless, or nullified. The assumption is that the legislature will not contradict itself. And then what is the presumption here? There is a concept of presumptions that we have to read. I think it's important. Presumption is the legislature would have put those in place for a purpose. So both have to stay. So how do you resolve that conflict is the court's headache. Objective. This provides the court with a framework to find a happy medium and reasonable interpretation that allows both provisions to be exercised in connection with the legislation behind the two provisions. So there is a legislative intent behind the two provisions, and those should be looked into, and a harmony should be created between these two provisions. Application circumstances applies to resolve conflicts to the extent they may exit finishing between different sections, subsections, clauses, or even schedules of the same statute, whatever. Now, specific provision prevails over general provision. The second point kanakunta. Specific provision prevails over general provision. Central principle. If notwithstanding the rule of harmonious construction is applied, and if the conflict cannot be resolved, conflict resolve avani pakshamlo, we are still dealing with the first question. Conflict cannot be resolved. One provision is general and the other is specific, and specific provision prevails over the general. So when there are two provisions and one is specific and one is a general provision, the supremacy is always for the specific provision because the intent of the legislature is very clear there. Specifically expressed in a particular provision will override the intention in the general provision. Later in time or later in replacement, core principle. Where two provisions with the same act are completely irreconcilable and both are of equal specificity. So, oka case entante harmonious construction cheyali, conflict resolve cheyali because we believe that legislature has put it in a good intention and intelligent intention. Second case is when there is one specific provision and one general provision, and when there is a conflict between these two, the specific provision will gain supremacy. It will have more weightage than the general provision. The third thing he's talking is both the provisions are specific and have equal weightage. When two provisions in the same act are completely irreconcilable and both are of equal specificity, if one provision is enacted first and then the later provision is placed in a different section of the act, a presumptive basis would arise that a later provision at either the time of enactment if an amendment or the later in placement of original signifies the legislature's latest intention. So whichever has come later prevails. If both have the same specificity and are irreconcilable in conflict, what has been incorporated later? But enta clear ga cheptunnadante later by an amendment, ledante ade book lo ade statute lo in the later part of the same statute, whatever has come later, that will prevail ani cheptunnaru. Caveat, దీనికి కూడా caveat ఉంది. This is last resort rule and is usually only applied if there is one other consideration in the conflict resolution process which has failed or does not apply in a given legal provision. It is typically applied in judicial conflict and the earlier act eluding with the later act, but can still be applied internally, provided the conflict is truly intractable. Anyway, all this caveat is basically this last principle edaithe anukunnamo, which has been first rasindi kakonda later rasinde it will gain weightage ani, that rule they are saying should be applied as a last resort. It cannot be the first reference point. It should be the last, because if nothing else works, this rule should be adhered to. This is question number one. Question number two is about which has more weightage, substantive law and procedural law. If there is a conflict between these two things, which prevails? So what is substantive law? We all know. It defines rights, duties, liabilities, and creates the legally actionable cause of action. Basically, IPC, ivanni kuda substantive law. They established everything that is there in the law. Contract law, property law, criminal law, all these are substantive law. Procedural laws is how to implement the substantive provisions is what is procedural law. So what does it do? Governs the formality and machinery of the process of enforcement, administration, and or litigation of substantive law. So substantive law is there, and then it breathes life into substantive law, the procedural law. It brings it into action. So that is procedural law. Now, the general preference rule ఏంటంటే, in the case of great conflict between substantive legal structure and a procedural legal structure, the preference generally goes to the substantive law. Why? Because substantive law is the original law. A substantive law implement చేయడానికి procedural law పెట్టారు కాబట్టి. Rationale. Procedural law exists for the purpose of enhancing, assisting, and facilitating the judicial system on substantive persons' rights. Procedures are there to assist both, while substantive rights are the rights that we all possess as individuals. So substantive rights are supreme. Exceptions ఉన్నాయి దీనికి. What are the exceptions? The preference is not absolute. In the rare case, the procedural legislative provision is deemed to have superior effect by Parliament, as made abundantly clear, or is meant for the purpose of ensuring procedural fairness, that is critical for the exercise of substantive right. It may have precedence. However, if that is the case, that will either be expressly stated or very strongly suggested by the context of the Act itself. So there are some rare exceptions, rare cases where procedure gains much more importance than the substantive part. But in such cases, it will be very explicitly stated by the legislature that this particular procedure is important. It cannot be violated or negotiated with. అని అది క్లియర్ గా చెప్తుంది. Otherwise, the general preference rule is substantive law reigns supreme, and it prevails over the procedural law if there is an irreconcilable conflict between two. Now, the case studies here are Cholaram Relumal, which I have read earlier. I'm not going to repeat it. Basically, a Bombay construction rental దీనికి చెప్పారు కదా, Money Lenders Act came, penal provision. So this is Toluram Relumal. I'll read the second one, KP Varghese versus Income Tax Officer Ernakulam. The primary factual issue in this case was to pit with interpretation of Section 52(2) of the Income Tax Act, and whether this section permitted the income tax officer to assess tax on the difference of fair market value versus the assessment allowed in the sale of property. So basically, KP Varghese sold some property and he paid income tax based on the realization price, but actual market price is much higher than what he claimed to be the price he realized. So now, what is the deal? The Supreme Court strongly stated that a statute must be read as a whole, and the provision should be interpreted in context and not separately. It endorsed the principle of harmonious construction. So it said you cannot read bits and pieces. The provision should be read as a whole and interpreted in the complete context. It endorsed the principle of harmonious construction and said, where there appear to be two provisions of the same statute relatively in conflict, these must, of course, be so interpreted as to reconcile them and permit effect to both. So first important thing is you try to resolve the conflict and make a harmonious coexistence. The court recognized that liberal interpretation would lead to improbable result of absurdity, injustice, or a contradictory internal conclusion, and that should not apply, but rather a purposive and contextual interpretation. So he's saying if it is a literal interpretation, it would lead to an absurd outcome అని చెప్పింది కోర్టు ఈ కేసులో. లిటరల్ ఇంటర్ప్రిటేషన్ చేయకూడదు, వర్బాటిం చేయకూడదు. Purposive and contextual అంటే with what purpose, in what context this particular statute has been enacted అనేది ఆలోచించాలి. That serves the principle of harmonious construction. When that purposive construction is made, purposive interpretation is made, we can bring harmony between the conflicting provisions, and a court has decided. In this case, a literal interpretation would create an anomalous and unjust result, leading the court to apply a restrictive interpretation compatible with Act's general scheme of something, Section 52(2). So anyway, the important thing is that the interpretation, how it should be, and any purposive interpretation. Legal principle. This case is likely to be predominant authority for the principle of harmonious construction. serving as the precept for resolving internal conflicts in a statute and a means for statutory interpretation that emphasizes the holistic approach rather than a piecemeal fragmented approach. So basically, KP Varghese versus ITO case law, court said that read the statute as a whole, not in bits and pieces. This will help in harmonious construction of the conflicting provisions అని చెప్పింది. So now what is the application? The number one and most important step is to apply the principle of harmonious construction. The court will carefully inspect the language of both seemingly conflicting provisions to see if they can be read together in a manner that preserves the legislative intent behind each provision. So that is the crux. Legislative intent should be preserved. And therefore, a harmonious construction should be the first thing that court should resort to. Often, courts must ascertain the character of provisions and identify the scope or purpose, or identify whether one is a general rule while other is an exception. For example, if one provision states no person shall and another states provided that a person may, the provision will be an exception to the general rule. If the reconciling effect has not distinguished to true irreconcilability, that is, it has not been possible to give effect to both without rendering one or the other negatory, the court will then utilize secondary rules. So basically what they are saying is where harmonious construction is not possible, the court will resort to indaka manam anukunnattu second rule. Second rule is the specific provision gets preference over the general provision. If one provision relates to all contracts generally and the other relates to sale of goods specifically, the article that references the sale of goods will prevail over the general provision of all contracts. The third rule that we can resort to, the last resort, would be if two provisions are equally specific and irreconcilable, the one that was added later as an amendment, it may indicate the new legislative will of the later provision. So legislative will is indicated by what is added most recently and JP, that will get weightage. Therefore, if courts are very hesitant to declare any provision negatory, they wish to exhaust all other attempts to reconcile other provisions before holding one negatory. So in this case, one should be negated kabatti. The courts will be extremely careful. So this answers the first part of the question. The second part is procedural and substantive law. The propensity is for substantive law to prevail over procedural law. Procedural rules are developed with the view of encouraging the fair and just application of justice and not to obstruct or eliminate substantive rights. For example, if substantive law gives a person a right of appeal, it cannot have that right extinguished by procedural law, but it can dictate the manner in which it is exercised. So if the conflict is where the procedural law is extinguishing a right that is being given in substantive law, then procedural law will not hold any water. However, if a procedural provision actively seeks to be a condition precedent to the exercise of substantive right, and importantly, the breach of non-compliance will impact the breach of enforceability of the right. For example, here is the time for you to file your suit. With doing so, your right is time barred. Then it may be appropriate to look into the procedural provision. Until there are some exceptions where procedural provisions gain supreme because they are more significant than the substantial part. For example, if you have to file a suit within a limited period of time, that is a procedural constraint, but it is very important because otherwise it will be time barred. Will govern or limit the substantive right in some manner. The question is now to decipher the legislative intent. So legislative intent అనేది ఇక్కడ decipher చేయాలి. Is the procedural provision simply a directory provision or in fact mandatory to the exercise of right? Is it mandatory for exercise of right or it's only gives a sense of direction అనేది decipher? If the procedural provision is mandatory and legislative intent is very clear on that, it will prevail over the substantive law. So the conclusion, in cases of two provisions of the same act, courts must resort to rule of harmonious construction, blah, blah, blah. Then finally, reconciling the conflict between substantive law and procedural law, the general tendency is for substantive law to prevail because procedural norms generally are to facilitate the dispatch of rights and not infringe or extend them. Courts will generally want to read the act holistically, reconciling each provision or aim to give effect where they exist. Anyway, I know I'm skipping much little bit because it is a repetition. Is that okay?
Yeah, it's okay, madam. Endukante we don't have time kada. 18 questions cheyali.
Correct.
So no, we have to do very short. I think we have to simplify. If somebody has already read the case, they can summarize.
Okay.
దట్ విల్ బి ఈజియర్. ఎందుకంటే ఎలాగో వాళ్ళు చదివి గుర్తుంచుకోరు. బేసికల్గా ఏంటంటే వాట్ ఈస్ ద క్రక్స్ ఆఫ్ ఇట్, ఏం రూల్స్ అప్లై అవుతున్నాయి, కేసెస్ ఏంటి అని మనం క్విక్ గా
సో
చెప్పేస్తే
ఈ కేసులో సో అయితే ఫోర్త్ కేసులో దిస్ ఇస్ స్ట్రీట్ అఫెన్సెస్ యాక్ట్ ఇస్ ఎ పీనల్ స్టాట్యూట్. ఓకే, penal statute law, we know that there is a strict construction, but it is in the favor, it is strictly whatever words are written should be understood. That's all. Inka mundu emi add cheyakudu. So in this case, the women were attracting, the women sex workers were attracting from the street, standing on the street and soliciting customers. There is a law that is saying that soliciting customers from the street is a penal offense. So the women said, okay, I'm going to stay in the balcony and then my windows and then I'll solicit from there. So someone put a case saying that adi kuda wrong kada mari, does it not fall under the thing of soliciting customers from open area ani. So ikkada what is the thing, strict construction of penal statutes. One literal rule implement cheyali, rules of interpretation lo literal rule, rules of construction lo strict construction. Strict construction prakaram akkada word em vaadaru, cannot be physically present on the street anna word vaadaru. Therefore what they are saying is, కేస్ స్టడీస్ కూడా చదవట్లేదు, ఇందాక చదివిన కేస్ స్టడీస్ తోలారాం రెడ్లుమాల్ వర్సెస్ స్టేట్ ఆఫ్ బాంబే అండ్ ఆర్ఎస్ నాయక్.
వాళ్ళు ఫ్రేజ్ ఇన్ ఏ స్ట్రీట్ వాడారు,
ఆన్ ఏ స్ట్రీట్,
ఇన్ ఏ స్ట్రీట్.
అదే చెప్తున్నా.
ఓకే చెప్పండి.
అదే చెప్తున్నా, ఫిజికల్లీ స్టాండింగ్ ఆన్ ఏ స్ట్రీట్ అనేది ఉంది ఆ యాక్ట్ లో, వాట్ ఎవర్ యాక్ట్, స్ట్రీట్ అఫెన్సెస్ యాక్ట్ లో ఫిజికల్లీ ప్రెసెంట్ ఆన్ ద స్ట్రీట్ అనేది ఉంది. బట్ సో అది దట్ షుడ్ బి రెడ్ వర్బాటిమ్ అంటున్నారు ఈ దీంట్లో, బికాస్ ఇట్ ఈస్ ఎ పీనల్ స్టాట్యూట్. పీనల్ స్టాట్యూట్ లో ఎవ్రీథింగ్ షుడ్ బి రెడ్ యాజ్ ఇట్ ఈస్ కదా. సో అప్లికేషన్ ఏంటంటే, ఐఎమ్ గోయింగ్ టు ద అప్లికేషన్ పార్ట్. లిటరల్లీ మీనింగ్ ఆఫ్ ద ఫ్రేజ్ ఇన్ ఏ స్ట్రీట్, it is absolutely clear from the literary, ordinary and grammatical meaning of the phrase in a street that the use of in means physically present in. A street generally refers to area of public passage and thoroughfare for members of the public to walk or drive their vehicles on. A balcony or window is a part of a building, which is an area that is a private and semi-private and is a space that accords a person to the window or the balcony a view of the street but not actually on the street. So basically literal interpretation kabatti, in a street physically present. So first it is not a street, second not physically there. The fact specifically states that women are not physically present there. The women was located in a space which is separate and distinct from a street. So mandating strict construction in the above cases, what is the conclusion? Ikkada reasonable doubt okati undi, I'll read that also. Strict construction ఏంటంటే in a street లేరు, physical presence లేరు కాబట్టి మనం దాన్ని offense కింద కన్సిడర్ చేయకూడదు అనేది. Reasonable doubt ఏముండొచ్చు అంటే, when a language in a street does not clearly and unequivocally catch conduct of the type soliciting from a balcony or window, does use of balcony create an uncertainty regarding the geographical context? Are a balcony or window included on ante, what you should apply is apply reasonable doubt and conclude. So ikkada ambiguity undi kada koncham, aa ambiguity lo benefit of the accused మాత్రమే మనం conclude చేయగలుగుతాం. In penal statute, any ambiguity will be concluded for the benefit of the accused. It will be in favor of the accused. So even under reasonable doubt, it will be in the favor of the accused. So conclusion is, based on the principles of strict interpretation of penal statute and application of literal rule to the term in a street, soliciting from a balcony or window does not amount to soliciting in a street in consideration of the words of the Street Offences Act. So that is the conclusion. Any questions on this? Any questions?
No, ma'am. I'll take it from here.
Everyone else? Yeah, please.
Okay. Fine and malli chuddam. Okay. We'll go to the next question, which is basically question 5. So basically, long story short, a student has paid fees to an education institute, and later he files a complaint alleging that deficiency in education services. Broadly, the institution argues that education is not a service under the Consumer Protection Act. So the student cannot be a consumer. Student to consumer kaadu as per CPA. This creates a legal dilemma. So a legal dilemma is whether student falls on the act protection or, and which basically interpretative rule enti, what does this apply? So this is broadly the facts and the issue. So coming to the what are the rules? So there are two rules which we are talking, which is basically beneficial construction cheste. How can we interpret it? Beneficial construction చేసినప్పుడు ఏమవుతుందంటే welfare statutes like CPA must be interpreted liberally. So whatever the Consumer Protection Act liberally interpret చేయాలని చెప్పారు to advance their purposes. Okay, the CPA aims to give simple, inexpensive and speedy remedies, right? So ఇంకోటి ఏంటంటే strict interpretation welfare కాబట్టి CPA is a welfare statute కాబట్టి strict interpretation చేయకూడదు. So one, what we have to remember is beneficial construction cheyochu because it is a CPA and is harmonious, strict versus liberal, ivanni akarledu, don't worry. Just remember the beneficial construction which we have to do because it is a welfare statute. So cases ఇప్పుడు సేమ్ స్టూడెంట్ కని లేదు, సిమిలర్ కేసెస్ ఏంటంటే ఒక లక్నో డెవలప్మెంట్ అథారిటీ వర్సెస్ ఎంకే గుప్తా అని ఒక ఆయన ఉన్నారు. సో అందులో ఏం చేశారంటే దిస్ వాజ్ లైక్ ఎ సిమిలర్ కేస్ వేర్ what they did is service provider and public housing authorities will fall under service provider Consumer Act prakaram annappudu the court took a liberal stance and said yes, it will fall into the service provider. Usually courts lo emothundante Consumer Protection Act lo service, the definition of service chala broad ga interpret chestunaru. Damages, deficient or defect ఇట్లాంటి వర్డ్స్ వచ్చినప్పుడు కన్జ్యూమర్ ప్రొటెక్షన్ యాక్ట్ కన్జ్యూమర్ సైడే ఇంటర్ప్రిట్ చేస్తుంది. సో దిస్ ఈస్ వన్ కేస్ వేర్ ఇట్ ఈస్ నాట్ సిమిలర్ టు స్టూడెంట్స్ బట్ ఇట్ ఈస్ జస్ట్ టు షో దట్ ద కన్జ్యూమర్ ప్రొటెక్షన్ యాక్ట్ వేర్ ఇట్ హ్యాస్ ఇంటర్ప్రిటెడ్ సర్వీస్ ప్రొవైడర్ యాజ్ పబ్లిక్ హౌసింగ్ అథారిటీస్ ఆల్సో. సో కమింగ్ బ్యాక్ టు ద ఈ తొల్లురం ఇంకా అవసరం లేదండి ఈ కేసు, యూ డోంట్ నీడ్ టు డూ వన్ కేస్ ఇస్ ఎనఫ్. కమింగ్ బ్యాక్ టు ద అప్లికేషన్, what we are saying is okay, student fees pay chestunadu, he is giving some consideration, so and for receiving education, okay, which includes teaching, infrastructure, administration, evaluation. So basically oka consideration esi meer oka teeskuntunnaru kabatti it qualifies as a service but it is not under CPA. So అందుకని ఏం చేస్తానంటే following the Lucknow Development Authority, the CPA సిమిలర్ గా ఉంది కాబట్టి అంటే సిమిలర్ ఇన్స్టెన్సెస్ లో ఇలా ఇచ్చారు కాబట్టి ఇది కోట్ చేసి మనం వీ కెన్ ఆస్క్ సేయింగ్ దట్ స్టూడెంట్ కూడా కన్జ్యూమరే అని అడగొచ్చు అండ్ దెన్ వీల్ క్వాలిఫై ఫర్ పుటింగ్ ఏ కేస్ ఇన్ ద CPA. So this is what is in short, and conclusion ఏంటంటే the student that avails education service and pay fees can only be considered a consumer under consumer protection. That should not be considered otherwise. We arrive at the conclusion by applying beneficial construction, which is preferable approach to interpretation with respect to welfare legislation. Okay, the Supreme Court firmly and definitively Lucknow Development Authority liberal interpretation ఇచ్చింది కాబట్టి okay, strict construction అవసరం లేదు. Therefore, the interpretation extends protection to student as consumer must be preferred to ensure students fit the fit beneficiary class of the act. So we are saying that yes, he is a consumer because we are assuming that the Consumer Protection Act might interpret that in a beneficial construction because it is a welfare statute. Okay, any questions? Okay, I'll move on to the next one. So what I'm trying to do is keep it very simple, guys, so that we can just what is that you need to remember for the exam again, and if you want to write more details, you can get into the case and read and write it. So the sixth case basically is a law against public smoking that came into force in 1st April 2020. Person was charged of smoking on 31st March 2020, and one day before. In a second case, during the trial of a person under an act, the act was repealed during the course of a trial. Okay, so what is the outcome of prosecution prior to commencement and the effect of repeal while under trial? So there are two scenarios. Okati entante retrospective law, a law banning public smoking that came into force on a particular date, but the accused was not smoking on that day before the law began. Scenario 2 ended effect of repeal, accused in trial for an offense under some 2009 act. While the trial is pending, the act is repealed in 2013. సో దానికి ఏంటి? So what are the issues and can a person be prosecuted for an act committed before the penal law came into force? That is the first question. The second question is, does the repeal of penal statutes during a pending trial automatically terminate the proceedings? So let's go to the first one. So basically clearly Article 20 Constitution of India ఏం చెప్తుందంటే protection against ex post facto loss. That means that no person shall be convicted for an offense unless it was an offense at the time of the act. And at the time of the act, you need to have that rule. Legapote, no person can be convicted. That is the first thing. Second thing, no person shall be given a greater penalty than what is existed at that time. Okay. And this guarantees certainty and fairness, preventing retrospective creation of criminal offenses. The second thing basically section 6, which is basically on the effect and repeal. For the second scenario, repeal doesn't affect liabilities or penalty incurred under the repeal law unless the repealing law says otherwise. So legal proceedings, investigations, penalties continue. So ఒక లాని రిపీల్ చేసినప్పుడు కొత్త లా వచ్చేదాకా పాత ప్రొసీడింగ్స్, ఇన్వెస్టిగేషన్స్, పెనల్టీస్ కంటిన్యూ. Okay, as if the law was never repealed. So that is a very important thing which you have to remember. Okay, so this ensures continuity and prevents injustice of chaos. ఇప్పుడు ఒక లాని సడన్ గా తీస్తారు, ఇంకో లా లేదు. సో ఏమవుతాయి? సో unless the new law comes and the procedures and everything come, పాత లా ఉన్నట్టే we assume అన్నమాట. That's what you have to remember. Okay, so if you go to the cases, ఈ తొల్లురామ్ కేసు ప్రతి చోట వచ్చింది, just forget about it. We'll go to the second case, which is State of Punjab versus Mohir Singh. So basically long story short, ఈ కేసులో ఏంటంటే this is a classic case where they said that the repeal does not extinguish the pending proceedings unless the repealing statute clearly intends to do so. So basically clear ga em cheptundante, babu, repeal doesn't extinguish penal proceedings unless the repealing statute clearly intended. A repealing statute lo clear ga chepte gani it is not valid. So under section 6 of the General Clauses Act, okay, pending trials continue as if the old law was in force. Okay, so there are two things which we have to remember. And State of Punjab versus Mahir Singh lo clear ga idi Supreme Court cheppindi that it quoted the section 6 of General Clauses Act and said, and pending trials will continue as if the old law are still in force. Okay, and if you look at 1 minute. The first scenario. So what are the applications for the first scenario? So first scenario lo anyway the act of smoking happened one day before, aa roju rule ledhu kabatti he is not prosecuted. Second ended repeal during a trial. The trial started, law was in force. So applying the section 6 and Mohir Singh, the repeal doesn't stop the trial. The trial continues as if act was in force. So conclusion ఏంటంటే the prosecution for smoking is invalid. The pending trial under the repeal act continues as if it is unaffected. So these are the broadly the thing which the question 6 is saying. Any questions? Ma'am, if you want to add also, I'm just summarizing. Yeah.
No, it's perfect. This is really
Okay. So the question 7 ఏంటంటే, so basically A gifted 50,000 to his friend B on September 1st, 2020. The income tax sought to leave income tax on the amount. The income tax notice పంపించింది అనమాట. బాబు నీకు గిఫ్ట్ వచ్చింది ఏ నుంచి, సో బిని ట్యాక్స్ కట్టమని అడిగారు అనమాట. ఇష్యూ ఏంటంటే గిఫ్ట్ 50,000 రిసీవ్ ఫ్రమ్ నాన్ రిలేటివ్. ఆయన రిలేటివ్ కాదు, నాన్ రిలేటివ్స్ అని క్లియర్గా చెప్పారు క్వశ్చన్లో. taxable as income from other sources under section 56. There is no way we can remember which rule of statutory interpretation applies in construing taxing statutes. So in this what we are saying is basically long story short, in section 56 of income tax was basically saying that 50,000 exceeding 50,000, more than 50,000 aitene tax kattali ani. So a statute, I think I just quoted it, but there is a threshold of 50,000 that came into effect on October 16,000.
But
so
I have one question. Sorry to interrupt. How are we supposed to remember Income Tax Act, which we have never read so far?
yeah, That's the same question I also have, madam, but
Okay.
Okay. Yeah, so it's difficult, but nobody will know 50,000 paina below 50,000 అయితే gift applicable కాదు, above అయితే applicable అవుతుంది అని. I think CA guys will know. ఈ క్వశ్చన్ అందుకని మీరు దీంట్లో వదిలేసేయాలన్నమాట, చాయిస్. So coming back to the
already second question choice లో వదిలేసాను సార్.
సార్
ఆల్రెడీ సెకండ్ క్వశ్చన్ చాయిస్ లో వదిలేసాను.
వదిలేసారా మీరు, మైండ్ లో వదిలేసారు? సెకండ్ క్వశ్చన్ చాలా ఈజీ సార్, మేడం చాలా లెంతీగా చెప్పారు. ఓకే ఓకే, సో కమింగ్ బ్యాక్ టు దిస్ థింగ్, 50,000 అన్నారు కదా. సో బ్రాడ్లీ ఏంటంటే 50,000 ఈజ్ లిమిట్. సో you can look at a strict into implementation and all those things, but bottom line ఏంటంటే application uses amount gifted is 50,000, so statutory language is exceeding 50,000. so applying strict, so వాళ్ళు చెప్పినట్టే we are applying the strict construction. 50,000 above 50,000 కన్నా above లేదు కాబట్టి the thing is invalid అని చెప్పొచ్చు, because it is the 50,000 gift is not taxable అని చెప్పొచ్చు broadly. Okay, if you know that 50,000 is a limit, otherwise this question cannot be answered. We'll move to the next one. Any questions, guys? Okay, so we'll go to the next question, basically, which is exclusion of jurisdiction of civil courts. Broadly ఏంటంటే a plaintiff filed a civil suit, defendant objects, claiming that special statute ఉంది that bars civil court jurisdiction by implication. అంటే వాడు కాంట్రాక్ట్ లో స్పెషల్ స్టాట్యూట్ రాసుకున్నాడు that bar civil court jurisdiction by implication. So no express exclusion clause exists. This issue is whether civil court jurisdiction can be excluded without an express bar and how courts interpret such claims. So అలా రాసుకున్నప్పుడు ఏంది, what is the issue, what are the issue and what are the rules? So section 9 of the civil procedure code ఏమంటుంది, civil courts have jurisdiction over all sorts of civil nature unless expressly or impliedly barred by a statute, అంటే not by agreements. So principles of so this is a presumption in favor of jurisdiction, exclusion is an exception. So what is basically an exclusion? Principles of interpretation enti, express inclusion enti, must be clear, explicit and unambiguous in the statute. So the most important thing we have to remember is what explicit provision undi antunnadu kada. Explicit provision ante it must be clear, unambiguous, explicit, and it should be in the statute lo undali, lekapothe it is not valid. Okay, and then necessary and inevitable implications untai. If not express, exclusion must arise only from a necessary implication from a scheme, language and purpose of the statute. So basically everything should be in the statute lo lekapothe mana any agreements raskunna, those are invalid. So broadly, if you go to the key cases, so Dalubai versus State of Madhya Pradesh held that exclusion of civil courts must be express or by necessary implementation and only when adequate remedy exists. సో ఇందులో లాంగ్ స్టోరీ షార్ట్ ఏంటంటే, మీరు అలా సివిల్ కోర్ట్కి వెళ్ళకూడదని రాసుకున్నా, ఎక్కడుంది ఎక్స్ప్రెస్ మస్ట్ బి, వేర్ ఈజ్ ఇట్ రిటర్న్, ఇన్ విచ్ స్టాట్యూట్ ఇట్ ఈస్ రిటర్న్ ఫర్ విచ్ యూ కమ్ ఎక్స్ప్రెస్ ఆర్ బై నెసెసరీ ఇంప్లికేషన్ అండ్ వెన్ అడిక్వేట్ రెమెడీ ఎగ్జిస్ట్. అండ్ అసలు మీరు రెమెడీస్ ఉన్నాయా, బికాజ్ మీకు ఎవరికన్నా యూ కెనాట్ డినై జస్టిస్, రైట్? సో వాట్ ఆర్ ద రెమెడీస్? సివిల్ కోర్ట్ వెళ్ళొద్దు అన్నప్పుడు వాట్ ఆర్ ద అదర్ రెమెడీస్ దట్ ఆర్ అవైలబుల్? And the same thing with SP Gupta and Union of India, where emphasized the access to justice and warned against readily inferring ouster of civil courts. So civil court ki మేము వెళ్ళకూడదు అని మీరు రాయకూడదు అని SP Gupta versus Union of India ఆ కేసులో బేసిక్లీ లాంగ్ స్టోరీ షార్ట్ ఏంటంటే చివాట్లు పెట్టారు అన్నమాట. So application ఏంటంటే as the statute has no express bar, the presumption of civil court jurisdiction applies. Okay, so what they're saying is the presumption of civil presumption in anything, it is presumed that you can go to a civil court. What the court will look at is, maybe it will look at a self-contained code, which is basically creating exclusive jurisdiction or finality clauses. making tribunal decisions conclusion. So basically ఏంటంటే if they are absent, civil courts retain jurisdiction. So మీకు end of the day, long story short ఏంటంటే if you do not have any remedy of going to any courts or tribunals or anything, civil courts retain jurisdiction. అంటే సమ్ టైమ్స్ ఏమని రాసుకుంటారంటే సివిల్ కోర్ట్ వెళ్ళొద్దు, ముందు ఆర్బిట్రేషన్ వెళ్దాం, ఆర్బిట్రేషన్ పెట్టుకుందాం, ఆర్ వీల్ డూ సంథింగ్. సో ఇఫ్ దెర్ ఆర్ నో రెమెడీస్ that are possible to go get justice, then by default civil court retains jurisdiction. That is one thing you remember. Okay, in civil court వెళ్ళకూడదు అని రాసుకోవడానికి లేదు. సో ఎక్స్క్లూజన్ కి కొన్ని ఇవి ఉన్నాయి. దట్ ఈస్ వాట్ ఐ అండర్స్టూడ్. నిర్మలా మ్యామ్, am I right or?
You are right. You're right, but the question itself is too vague for me. I don't know how you were able to infer so many things from the question as I'm reading it. Making the facts the pine question at like say, how will you infer so many things? But agreement lo raskunnadu ivanni నాకు తెలియట్లేదు.
అంటే హైపోథెటికల్ కదా అంత. నా ఇంటర్ప్రిటేషన్ అది.
ఓ అదే ఓకే. సరే.
ఓకే నెక్స్ట్.
Go ahead.
Okay, ma'am, we'll move ahead. This question is basically validity of unregistered eviction notice. So basically, landlord Y serviced an eviction notice to tenant Z using unregistered method, not by registered post. So Z received it and remained silent, raising no objection. The issue is whether such an unregistered but received note is valid for commencing eviction proceedings. So basically, what is the issue? Issue ఏంటంటే is a non-registered eviction notice which has been actually received by a tenant and not objected. వాడికి వచ్చింది, వాడు acknowledge చేస్తాడు. Valid and legally sufficient to allow landlord to initiate eviction proceedings. So the purpose ఏంటంటే what are the rules? So what are the rules is basically purpose of notice requirements is basically a substantial compliance. So the purpose of notice is to inform the recipient. Okay, then actual communication matters more than
contracts one lo chadukunna.
Ma'am?
Law contracts 1 first semester లో చదువుకుంది, ఇప్పుడు అడిగితే ఎట్లా గుర్తుంటుందబ్బా? ఎనీవే గో హెడ్. ఐఎమ్ సారీ, ఐఎమ్ క్రిబింగ్.
Yeah, that's okay. So అంటే రూల్స్ లో ఏంటంటే వాట్ ఈస్ ద పర్పస్ ఆఫ్ ద నోటీస్? సో వై we are sending a notice is for some compliance, right? So the purpose of a notice is inform the recipient. Actual communication matters more than the form of method or service. So liberal interpretation of procedural rules తీసుకున్న procedural provisions are interpreted liberally and flexibility to promote justice. So in the ఏంటంటే courts unless the other person is objecting to it, courts avoid hyper technical objections. I think there is somewhere which I've written that on that. When no prejudice is shown. Okay, so a notice will not be invalidated merely because it was not sent in a prescribed mode if it achieved its purpose. Okay, bottom line and these are the three things: dislike or hyper technicality. So basically ఏమంటున్నామంటే notice will not be invalidated merely because it is not in a prescribed mode or if there is no prejudice shown, అంటే వాళ్ళు ఏం అబ్జెక్ట్ చేయలేదు. సో బేసికలీ ఇందులో 2 cases ఉన్నాయి. Sorry. What top line shows Corporation Bank, the Supreme Court of India in this case said if notice was actually received, a technical defect in the mode of service is irrelevant. So top line shows లో సుప్రీం కోర్టే చెప్పింది, బాబు వాళ్ళకి నోటీస్ వచ్చింది అంటున్నారు, వారు రిసీవ్ చేసుకున్నా అంటున్నారు, ద మోడ్ ఈజ్ ఇర్రెలవెంట్, వాడికి రీచ్ అయిందా లేదా ఇంపార్టెంట్. వన్స్ ద ఆబ్జెక్ట్ ఆఫ్ సర్వింగ్ నోటీస్ ఇస్ అచీవ్డ్, ద మోడ్ బికమ్స్ ఇన్కాన్సిక్వెన్షియల్. సో నెక్స్ట్ కేసులో కూడా కేదార్నాథ్ స్టేట్ ఆఫ్ వెస్ట్ బెంగాల్లో కూడా త్రూ a criminal case, it laid down the general principle the procedural defects do not vitiate proceedings unless they cause prejudice. So we really ఈ కేసులో కూడా ఏమంటున్నారంటే ప్రొసీజరల్ డిఫెక్ట్స్ ఉంటే డు నాట్ విషియేట్, అంటే ప్రొసీజరల్ డిఫెక్ట్స్ ఉన్నందుకు సిఆర్పిసి ప్రొసీజర్ని ఆపేయలేము మేము. ఓకే, అండ్ so the same thing we might apply to this is basically a criminal court. Maybe just ఇది క్లియర్ గా ఉంది కాబట్టి టాప్ లైన్ షూస్ ఒక్కటే రాయండి సరిపోతుంది. This is a clear analogy in the criminal side which we don't need to write. So basically, coming back to the application, Z actually received the notice and raised no objections, meaning the object of the notice is fulfilled. So applying top line shows the mode is immaterial. So there is no claim of prejudice by Z. So prejudice ledu vadiki. So requiring strict registered service despite actual receipt would elevate form over substance and defeat justice. So conclusion is the unregistered eviction notice is valid and Y can proceed with eviction since Z received it and did not object and the purpose of notice was served. Okay. Guys, I'm making it very short so that you understand the crux of it. And then if you want to write more material, just read through the case. So we'll go to the next case. Ma'am, should I read the next case?
Yes, please.
Okay, basically this I think is 2022 lo adigaru. It's an interesting case. Basically 2022 lo adigaru and 2019 lo this 497 was removed. So the case basically the case is about the constitutionality of section 497 Indian Penal Code, which is basically adultery. So B, a married woman, A pleads discrimination as B was not prosecuted. So adultery law 497 law, when they were caught, basically our time only husbands, the man ne తీసుకెళ్తారు, woman తీసుకెళ్తారు. So he was saying that discrimination on the only none తీసుకెళ్తున్నారు, ఆవిడని తీసుకురాలేదు. So bottom line ఏంటంటే issue is whether 497 IPC, which punished only the man and accused the woman in the act of adultery, was constitutionally valid under Article 14, 15 and 21 of the Constitution of India, whether A's plea of discrimination is valid. So A's plea of discrimination valida kada. So what are the relevant constitutional provisions? Article 14 is equality before law. Article 15 prohibits discrimination by any state on the grounds of sex. And Article 21 protects the dignity, autonomy and personal liberty. Okay. So section 497 punished a man having sexual intercourse with a married woman without her husband's consent. The woman was not punishable even as an abettor, treating her as a passive victim. Okay. And this is what is the issue with section 497. So key case in Joseph Shine versus Union of India. There is only one case which you have to quote. And you don't need to quote the Toluram case. So Joseph Shine case, a short story in the Article of India struck down the 497 in 2019 as unconstitutional. It violated Article 14, arbitrary general classification, punished only men. Article 50 discriminated solely on basis of sex, and 21 treated women and husband's property, denied their sexual autonomy and dignity. So in moodu kabatti, so and then it said adultery is a private wrong and it can be a basis for divorce. So long story short, based on this 498 was invalid. So application 498 created unequal classification by punishing only men, violated the articles. Conclusion A's plea of discrimination is valid. Section 495 has been struck down and is unconstitutional anyways. So A's plea is valid. Okay. You have to remember this Joseph Shine versus Union of India case, which was in 2019. For this. Okay. So ఇట్లాంటి వేగ్ క్వశ్చన్లు అడిగి కూడా మనల్ని సావగొడుతున్నారు వీళ్ళు, బట్ దిస్ నథింగ్ వీ కెన్ డూ.
ఇంకా 11th నుంచి చూడండి ఇంకా ఎంత వేగ్గా ఉన్నాయో. 11th
అంటే నెక్స్ట్ 2-3 మేడం, తర్వాత లాస్ట్ 4 ఇస్ రిలవెంట్. I'll go through quickly.
Relevant కానీ బట్ 11 yeah.
Okay. 11 I'll go through quickly. So basically the topic is use of social, political, economic changes and scientific inventions. How do they aid in interpretations? It's basically like a more like an essay. External aids gurinchi adugutunnaru. So to what extent can courts consider social, political, economic conditions and scientific as external aids to interpret old statutes whose language seems outdated, ensuring the law evolves with the society. So basically, this is what the issue is. And I mean, if you go back to the rules, what are the external aids which we use? I think we have learned in the part B, legislative history, parliamentary debates, so committees, so all these are there, used to identify the misuse to be remedied as just legislative purpose. Okay, and the second one is the dynamic or updating construction. Basically, always speaking principle. Always speaking intent is statutes are always speaking and must be read to adapt the changing circumstances while respecting legislative intent. Okay, అవి కూడా అప్డేట్ చేయాలి. ఇప్పుడు what case I remember in this is basically the Telegraph Act. So there was a case where Telegraph Act ని తర్వాత టెలిఫోన్స్ వచ్చాయి, తర్వాత మొబైల్ ఫోన్స్ వచ్చాయి. So Telegraph Act when it was applicable, the court said that since it is a mode of communication, telephone is also part of telegraph, and that's how they upgraded it. So that's how they're saying always speaking. Nowhere telephone and mention chesna. You have to constantly adapt to the changing circumstances while respecting legislative intent. Ensures law remain relevant and effective to society, and courts cannot rewrite statutes, only update meanings of general words to fit present context. So the first case is relevant here. Second case, you don't need to worry. The first case is State versus S.J. Chaudhary. Supreme Court of India accepted that definitions and evidence standards in rape must involve with medical sciences and societal understanding. So basically, I think this was the case where the first case, sexual assault అయినప్పుడు forensic medical science methodologies they wanted to bring 1996 law, because in US they are already prevalent. So what the Supreme Court said is ఇప్పుడు ఎవిడెన్స్ ఏదైతే మనం తీసుకున్న ఎవిడెన్స్ స్టాండర్డ్స్ ని మస్ట్ ఎవాల్వ్ విత్ మెడికల్ సైన్స్ అండ్ సొసైటల్ అండర్స్టాండింగ్ బట్టి మనం కూడా ఎవాల్వ్ అవ్వాలి అని చెప్పింది ఈ కేసు. Okay, so basically application ఏంటంటే social changes affect interpretation of terms like obscene, family or gender equality, and then political changes like constitutional amendments influence how older laws are applied. Economic changes require adopting laws on taxation, competition or trade or modern and finally scientific inventions. There are a lot of scientific inventions, right? So basically, mundu document means only document, but right now document means digital files. Communication includes electronic messages, and evidence includes DNA and cyber forensics, right? And so courts apply these contexts to bridge temporal gaps till the new laws have come. The IT Act వచ్చే mundu, they used to treat all this about. So conclusion is courts may legitimately use contemporary social political conditions and scientific external aids to interpret statutes. The dynamic or updating construction approach affirmed by S.J. Chaudhary case, okay, remains effective and aligned with the present realities. So that's what it is. Okay. Any questions? Ma'am, this is again my way of interpreting the question. I took a beneficial construction approach to write the answers in the welfare of everybody. Can I move on to the next one? We have 4 or 5 left. Hello?
Yeah.
Okay. So the next question is also basically about the mischief rule. It is a critical appraisal of Hayden's rule or a mischief rule. Basically, what are the facts is statutes are enacted within a socio-legal. What is a statute is not passed in vacuum, but in a framework of circumstances so as to give a remedy for a known state of affairs. To arrive at its meaning, one should know the circumstances, the reference to which the words were used and which the objects appearing from these circumstances which Parliament had in view. Make a critical appraisal on the light of Hayden's rule. And Hayden's rule ne manamu ijjayali. So basically, issue is how courts interpret ambiguous statutes to give effect to the true legislative intent and remedy the mischief the law sought to cure. And what are the strengths and weaknesses of relying on Hayden's rule? More or less, this is the issue. So Hayden's rule, if you
చదువుకున్నాం కదా, స్కిప్ చేసాను.
స్కిప్ చేసేయచ్చంటారా?
ఈ క్వశ్చన్ థియరీలో ఎలాగో చదువుతాం కదా, హేడెన్స్ రూల్ అండ్ మిస్చిఫ్ రూల్
గురించి ఎలాగో చదువుకుంటాం కాబట్టి
కాబట్టి స్కిప్ చేయరా ప్లీజ్.
Okay, ma'am. We'll go to the next question. Question 13, in distinction between penal and remedial statutes and interpretation rules. So, basically, what is the difference between penal and remedial statutes? Why interpretation rules apply to each? What is the current judicial trend in interpreting penal statutes? So, penal statutes, these are the three questions, three issues. So, penal statutes are basically strict construction. Penal statutes are interpreted strict construction into the loan of lenity into the no punishment until words clearly and unambiguously define the offense. Ambiguity favors the accused. Ambiguity on chota, it is accused ki favor healthy. Courts will not extend coverage by implication or analogy. Justification ఏంటంటే legal certainty and liberty require citizens to know how clearly what is prohibited. Okay, so same ఈ తొల్లురామ్ కేసు అయితే ఇక్కడ రాయొచ్చు, బికాజ్ బాంబే రెంటల్ యాక్ట్ లో 2 ఇంటర్ప్రిటేషన్స్ వచ్చాయి కాబట్టి లిబరల్ గా ఉన్న ఇంటర్ప్రిటేషన్ తొల్లురామ్ గారికి ఇచ్చి వాడిని బయటికి తీసుకొచ్చేసారు. Remedial statutes is basically rule. The statutes liberal or beneficial statutes, basically mischief rule or purpose of interpretation, meant to suppress the mischief and advance the remedy. So prefer interpretation that further access to justice and prevents the intended class, broadly and flexible reading to fulfill the state's purpose. Remedial statutes ko okkari cheppara meeru, what does definition?
Remedial statute is the one which tries to remedy the defect that is existed in the common law. So any statute that is passed where a defect has been remedied is a remedial statute. ఇంతకు ముందు ఉన్న లాలో కానీ ఇంతకు ముందు అసలు లా లేకపోయినా లా ఏమన్నా ఉండి దాంట్లో ఒక డిఫెక్ట్ నికి ఏమీ సొల్యూషన్ ఎత్తకపోతే దే రెమిడియల్ స్టాట్యూట్ ఈజ్ ఎనాక్టెడ్ సో దట్ ఇట్ విల్ రెమిడీ డిఫెక్ట్ దట్ ఈస్ ఆల్రెడీ.
Okay, so like ఇందాక లక్నో డెవలప్మెంట్ అథారిటీ వర్సెస్ ఎంకే గుప్తా అనుకున్నాం కదా, దట్ కన్స్యూమర్ ఫోరం గురించి మాట్లాడుతున్నప్పుడు దట్ హెల్డ్ కన్స్యూమర్ ఈజ్ బెనిఫిషియల్ డిసిషన్ మస్ట్ బి అందులో సర్వీస్ ప్రొవైడర్ లో యాడ్ చేశారు కదా పబ్లిక్ యూటిలిటీస్ కంపెనీ. సో దట్ మస్ట్ బి రెమెడీ బికాస్ వాళ్ళు లేరు కాబట్టి.
ఇప్పుడు ఐటీ యాక్ట్ ఉంది, ఐటీ యాక్ట్ లో ఇంతకు సైబర్ క్రైమ్స్ లేవు, యాడ్ లేదు. ఇప్పుడు ఐటీ యాక్ట్ ఎనాక్ట్ చేశారు బికాస్ సైబర్ క్రైమ్స్ అవుట్ సైడ్, అది కొత్తగా వచ్చింది కాబట్టి. సో ఐటీ యాక్ట్ లో సైబర్ క్రైమ్స్ ప్రొవిజన్ ఇస్ రెమిడియల్ ప్రొవిజన్, ఇట్స్ రెమిడియల్ స్టాట్యూట్ అట్లా.
Okay, so remedial statutes and if language allows, court expands scope to maximize benefits to protect a class. Okay, yes. So basically coming back to the penal statutes, what is the judicial trend and kuda adigaru. Bottom line is they have asked what is the judicial trend, which is basically judicial trends ఏం నడుస్తున్నాయి penal statutes లో current judicial trends అంటే strictness remains, courts still insist on clear language, do not create new offenses by implication, and contextual purpose shift, especially in economic offenses, public health or welfare crimes. Court consider the legislative purpose while interpreting. So legislative purpose ఏంటి అని చూస్తున్నారు, especially in the contextual purpose shift. Next, harmonious constructions. The penal provisions are read with the statute scheme as a whole to preserve coherence, and welfare linked penalties law in the laws of environment, corruption, food and food adulteration, court are slightly less literalistic if it supports a broader object without causing unfairness. Distinction between charging and machinery provisions, strict for charging sections, less rigid for procedure machinery provisions to enable enforcement. Different areas, but ultimately what is the bottom line is penal statutes are constructed strictly to protect liberty and ensure certainty, with remedial statutes are constructed liberally to fulfill the beneficial purpose. సో ఐ థింక్ ఇంటర్నల్ ఎగ్జామ్లో ప్రతి దానికి స్ట్రిక్ట్లీ అని రాస్తే బోల్డ్ అని మార్కులు వచ్చాయి కదా, అలాగే పీనల్ స్టాట్యూట్స్ ఆర్ కన్స్ట్రక్టెడ్ స్ట్రిక్ట్లీ, లిబరల్ స్టాట్యూట్స్ ఆర్ రిమైన్ లిబరల్. ఓకే, బాటమ్ లైన్ అదండి. అండ్ దెన్ we'll go. This is very broad, madam. చెప్పండి.
ఏం చెప్పాలి, అయిపోయింది. నెక్స్ట్ క్వశ్చన్.
No, we were talking something and మీరు అడిగారు అనుకున్నా.
No.
Okay, we'll go to the 14th question. So basically the question is about effect of a repeal of a penal statute on pending trials. I think this we have already studied kada, ఇందాక ఒక కేసులో కేస్ ఆల్రెడీ ఎగ్జిస్టింగ్ కేసు ఉన్నప్పుడు కేసు రిపీల్ అయితే మనం ఏం చేద్దామని. సో దిస్ ఇస్ a repeat, so I'll not go through it. మోహిర్ సింగ్ గురించి
Basically, you have to memorize the sections, the provisions under section 6 of the General Clauses Act. ఒక 4-5 provisions ఉన్నాయి, అవి బాగా గుర్తుపెట్టుకుంటే any case that's related to those provisions, you will be able to answer. Section 6 of General Clauses Act.
Okay, madam. I will move to question 15. Yeah. Question 15, can only 2-3 questions ఉన్నాయి. Okay.
ఇందాక ఉన్నాయి 15, 16, 17, 18, 4 ఉన్నాయి.
920 మేడం అయింది, కంగారు పడిపోతున్నారు.
అయింది కానీ చదవాలి కదండి, ఇలాగ నేను రాత్రి అంతా వెళ్ళిపోలేము.
Okay, we'll go to question 15, which is basically use of simultaneously drafted rules as aid to interpret the act. So issue ఏంటంటే, can rules framed under an act when drafted and enforced simultaneously and integrally with the act be used as aid to interpret ambiguous provisions of the act? లాంగ్ స్టోరీ ఏంటంటే, యాక్ట్తో పాటు రూల్స్ కూడా వస్తాయి. యాక్ట్స్ రూల్స్ were drafted together by the same team, published in the same gazette, came into force on the same day. So the act is described as unworkable without the rules. So a dispute arises requiring interpretation of the act. The question is whether rules can be used as aid of act. So general principles ఏమంటుంది, మన subordinate legislation rules is normally treated as external to that, but if integrally connected and necessary for its operation, they must be considered part of its legislative scheme. That's the first thing. Next, holistic construction. Courts presume that Parliament intended a consistent workable scheme. If the act is unworkable without the rules, they are read together to achieve coherence. That's what holistic or harmonizing construction says. And simultaneously drafting and enforcing by the same authority shows that one continuous legislative intent rather than two separate instruments. So the legislative intent basically is only one. So if you go back to the cases, there are 2 cases, State of UP versus Baburam Upadhyay. In this case, the Supreme Court of India held that rules framed under statute form part of legislative framework and may be clarify ambiguities in the parent act, provided they do not contradict it. So unless the rules and the act do not contradict each other, you can use them. And the second one is also basically Taj Mahal case held that interrelated rules are legitimate aids to interpret the act, where the act functioning depends on them. So it is okay to. So basically application into the acts and rules are inseparable, drafted and enforced together, forming one legislative package. So their simultaneous creation shows unified legislative intent. They illustrate how the legislator intended to act the function. So as in Baburam Upadhyay and Taj Mahal case, where the act is ambiguous, the rules can be consulted to clarify and give effect to its provisions. Denying their use would make the act unworkable, defeating legislative intent. So yes, when the rules are framed and brought into force simultaneously with the act and are essential to make the act workable, they may validly be used as aid to interpret the act. So answer is yes. The rules vaadacha ante yes, because the legislative intent when doing it was the same. There were no 2 separate acts kaavavi. That is the justification. Long story short. So 16th
అంటే ఇక్కడ ఒక క్యావియట్
చెప్పండి.
సారీ గో హెడ్. No, ఒక క్యావియట్ ఏంటంటే, let's say the act has been stipulated, the act has been enacted now with some rules. ఫ్యూచర్ లోకి అమెండ్మెంట్ చేసి ఇంకొక రూల్ పాస్ చేసినా ఆ రూల్ ను కూడా ఫ్యూచర్ లో ఇంటర్నల్ ఎయిడ్ గా వాడచ్చు ఇంటర్ప్రిటేషన్ కదా. జస్ట్ బికాస్ బోత్ సైమల్టేనియస్ గానే చేస్తేనే వాడాలి అని ఏం లేదు. ఈ కేసులో సైమల్టేనియస్ గా చేసుకున్నారు. రూల్స్, సబ్స్టాంటివ్ లా అండ్ ప్రొసీజరల్ లా సైమల్టేనియస్ గా చేశారు. బట్ ఫ్యూచర్ లో ఈవెన్ ఇఫ్ దే ఆర్ నాట్ సైమల్టేనియస్ వీ కెన్ స్టిల్ యూజ్ రూల్స్ అండ్ స్కెడ్యూల్స్ యాజ్ ఇంటర్నల్ ఎయిడ్స్ కదా. అంతేనా ఇంటర్ప్రిటేషన్ కి?
Ma'am, yeah,
Am I
yeah.
making sense or no?
Yeah. Correct.
Okay, thanks. Go ahead,
Okay.
go ahead.
Yeah, we'll go to the next question. This is, I think, Indaga I already discussed this, whether telegraph includes telephone, what is the dynamic interpretation of it. And basically the
Then
fact
don't do na. Always speaking rule.
Sorry?
Law is always speaking అనే రూల్ కదా ఇది.
Always speaking doctrine. Yeah,
Always. Adi. So I think we have done it unless people want to go through it again.
Okay. Only thing is the case, okay, relevant case on the.
సరే చెప్పండి. Yeah.
So basically ఇందులో ఈ senior electric inspector versus Lakshmi Narayan Chopra, Supreme Court of India held that telegraph line includes wireless transmission, though it was unknown in 1885 as it served the same function of transmitting messages. ఈ ఒక్క కేసు గుర్తుంచుకుంటే చాలు. వైర్లెస్ ట్రాన్స్మిషన్ అయినా కూడా టెలిగ్రాఫ్ యాక్ట్ కింద వస్తుంది. అంటే ఇందులో కంటెస్ట్ ఏం చేశారంటే వైర్ లేదు కదా కమ్యూనికేషన్ కి, ఎలా వస్తుంది అని. ఓకే, that's one thing which you have to remember. So I'll go to the next one. This is basically effect of repeal and reenactment on subordinate legislation. So this is already మనం చదువుకున్నాం కదా, రిపీల్ చేస్తే కంటిన్యూటీ ఉంటుంది అని. సో రిపీల్ కంటిన్యూటీ క్వశ్చన్ గ్యారంటీ గైస్. Okay, పాత రూల్స్ కంటిన్యూ till new things come into existence. And also it's section 24 of GCA kuda undi. If the Central Act is repealed and reenacted, then all rules, orders and modifications made under the repeal act shall continue in force, be deemed to be made under the new act unless they are inconsistent with the reenacted act or expressly superseded. This case already మనం చదువుకున్నాం. అంటే కేసు ట్రయల్లో ఉన్నప్పుడు రిపీల్ అయితే ఏమవుతుంది అని. దీనికి ఆల్రెడీ ఈ సుప్రీం కోర్ట్ జడ్జ్మెంట్ ఉంది. సారీ, వెళ్ళిపోయింది అక్కడ. ఇది గుర్తుంచుకోండి, స్టేట్ ఆఫ్ పంజాబ్ వర్సెస్ హర్నీక్ సింగ్. సో ద లాస్ట్ క్వశ్చన్, statute is choosing between two possible interpretations. So statute ఉంది, statute provision ambiguous గా ఉంది, two interpretations వస్తున్నాయి. One fulfills the object and purpose of legislation, the other undermines or frustrates. The court must decide which interpret to adopt. Issue ఏంటంటే when the provision is capable of two interpretation, which one would the court prefer? The one serving the legislative purpose or the one that defeats it? Okay. And the rule ఏంటంటే purposive interpretation చేయాలి. Hayden's rule ప్రకారం courts should interpret statute to suppress the mischief and advance the remedy. The purpose of the law prevails over mere literal meaning. Beneficial construction ఏమవుతుంది, especially for welfare of remedial laws. So in the third one is ut res magis veliet quam peret. It is better for the thing to have effect than to be void, and let law prevail. Statutes are presuming to be intended of work, not fail. So ఇవన్నీ రూల్స్ డాక్ట్రిన్స్ చదివినాక మనకి ఏమనిపిస్తుంది అంటే అప్లికేషన్ ఏంటంటే చూసింగ్ ద లిటరల్ బట్ purpose defeating interpretation would render the law ineffective. So and when two interpretations are possible, the court must prefer the one that advances the object and purpose of the statute. బాటమ్ లైన్ ఏంటంటే టూ ఇంటర్ప్రిటేషన్స్ ఉన్నప్పుడు మీరు మొత్తం నేర్చుకున్నంత రాసేసి ద ఆన్సర్ ఈస్ ద కోర్ట్ మస్ట్ ప్రిఫర్ ద వన్ దట్ అడ్వాన్సెస్ ద ఆబ్జెక్ట్ అండ్ పర్పస్ ఆఫ్ ద స్టాట్యూట్. దిస్ ఈస్ మోర్ ఇంపార్టెంట్. ఏ ఇంటర్ప్రిటేషన్ అయితే ఆబ్జెక్టివ్ పర్పస్ ఆఫ్ ద స్టాట్యూట్ ని ముందుకు తీసుకెళ్తుందో అది మనం తీసుకోవాలి. ఓకే,
Yes.
అంతేనండి. ది ఎండ్.
Okay. I have one question not related to the case laws, but ఈ లేబర్ లా అండ్ నిన్న మొన్న రాసిన PIL లో మనకి ఫస్ట్ 20 క్వశ్చన్స్ చదివితే దాంట్లో షార్ట్ ఆన్సర్స్ చాలానే వచ్చాయి కదా. హలో
వచ్చాయి కదా. హలో
హలో
చెప్పండి.
వచ్చినాయి
వచ్చాయి కదా. No, I'm
మీకు
just
time
banking
లేకపోతే
on first 20.
మీకు టైం లేకపోతే పార్ట్ బి మొత్తం 11 చదివేసేయండి. పార్ట్ ఏ 20 దాకా చదవండి. పార్ట్ సి ఎలాగో చదివేశారు.
ఓకే, అంతే చేస్తున్నా. పార్ట్ బి మొత్తం చదివాను. పార్ట్ ఏ
అన్ని క్వశ్చన్ మీనింగ్ చూసుకొని వచ్చినా సరిపోయా.
హెడ్డింగ్లు రాసేసుకోండి చాలు.
అదే
మిగతా కథ రాయండి. నాకు ఓపిక లేదు. iOS అది నాకు బుర్ర అంతా వేడెక్కిపోయింది.
Venu sir,
ఏం లేదు,
thank you for the 20
simple.
pages.
ఏదమ్మా
Thank you for those 20 pages. అది పంపించారు కదా, నేను అదే
హెడ్డింగ్స్ అన్ని తీసి పంపించాను తల్లి.
Yes,
దాని
thank you
డీటెయిల్స్
so
కావాలంటే
much.
నోట్స్ చదవండి.
ఎక్కడ
It's
వచ్చింది
there
అది?
in the group. It's there in the group,
Oh,
ma'am.
okay.
మీరు సపరేట్ నోట్స్
Okay.
ఎలాగో రాసుకుంటారు కదా మేడం, మీకు ఎందుకులేండి మేడం.
ఆహా.
మీకు ఎందుకండి మీకు అన్ని తెలుసు కదండి మేడం.
అన్ని వచ్చినా ఏమి రాయలేను పేపర్ ఎగ్జామ్ లో, అది ప్రాబ్లం.
మేమే నమ్మమండి తూచి మా
అసలు
కోసం చెప్తున్నా డైలాగ్స్.
అది
Anyway.
అదంతా ఏంటంటే ఇప్పుడు అంతా మేడం ఏంటంటే సబ్స్టాన్షియల్ లా, మనం ప్రొసీజర్ లా.
సార్ ఈ డైరెక్టర్
పేరుకే పెద్ద కనపడుతుంది ప్రొసీజర్.
Oh God. Let's see how we'll do.
Yeah.
చాలా
I will
concepts చెప్పండి.
హలో
బుక్ తెరిచి
నథింగ్ మ్యామ్. సో ఆల్ ద బెస్ట్ గైస్. చాలా చదువుకునేది ఉంది, నేను వెళ్ళాలి ఇంకా.
Yes, me too.
Same here.
Yes, all the best.
Okay,
All the
best,
best.
guys.
Yeah,
Take care.
thank you. Bye.
Thanks everybody. Bye.